In this lesson, we are looking at the main differences between criminal law and private/civil law. In English law, there are some significant differences between how criminal law cases and how civil/private law cases are dealt with. It is very important for you as a law student to understand these differences. The purposes of criminal law are different to the purposes of civil/private law. The courts in which criminal law cases are dealt with are different to the courts in which civil law cases are dealt with. Additionally, the outcome of criminal law cases are different to the outcome of civil law cases. There are also differences with regard to requirements for standard of proof and burden of proof. Criminal law is concerned with crimes and the consequences of committing them. Examples of crimes in English law include theft and murder. A crime is a crime because either Parliament has passed an act of Parliament or a statute stating that it is a crime, or case law or common law or judicial precedent tells us that it is a crime. In some cases, it is delegated legislation which tells us that a particular behavior or action is a crime in English law. So if we want to find out how theft is defined in English law, we turn to an act of Parliament, and we turn specifically to the Theft Act 1968. But if we want to find out how murder is defined in English law, we cannot turn to an act of Parliament because Parliament has never passed an act of Parliament defining murder. Instead, we turn to common law. The purposes of criminal law are to maintain law and order and to protect members of society. Now, because the state has the responsibility to protect members of society, when a person commits a crime, that person is said to have committed an offense against the state, and it is the state who normally starts legal proceedings against that individual. So it will not normally be the person who is the victim of the crime who starts the case in criminal law. It will be the state or agencies of the state who start legal proceedings against that individual. In English law, when a person has been charged with a crime, they will be tried in either a magistrate's court or a crown court. If the person has been charged with committing one of the so-called least serious offenses in English law, then they will be tried in a magistrate's court. For example, if a person has been charged with driving without insurance, then that trial would take place in a magistrate's court. But if the person has been charged with a very serious offense, known as an indictable offense in English law, then they will be tried in a crown court. An example of an indictable offense is murder. The party who starts the case is known as the prosecutor, and the party who has been accused of committing the crime is the defendant. The prosecutor has the burden of proof. This means that the prosecutor has a responsibility or carries the burden to prove to the court that the defendant is guilty of the crime that they have been accused of doing. Before the court can convict the accused or find them guilty of the crime, the court needs to be convinced beyond doubt that the defendant is guilty of the crime in question. That is why in criminal law we state that the standard of proof is beyond reasonable doubt. If the defendant is found guilty, then the defendant will be convicted. And if the defendant is found not guilty, the defendant will be acquitted. If the defendant is found guilty, they face one of the following consequences. They could either be asked to spend some time in prison, or pay a fine, or do unpaid work. The consequence they face depends on the crime they committed.